17 U.S. Code, Section 106, exclusive rights, work, everything happens under here. 70% of the income determined by statute, 30% is willing buyer, willing seller. Sync is pretty much the big one for willing buyer, willing seller. Licenses versus transfer of copyright is important. Types of work, joint works, master, P, who put up the money, or else otherwise is in the writing agreement for who owns the master. District 9 is where you would want to file for copyright issues. There's the CRB for small claims, copyright. You have the safe harbor. Statute obviously means law. Chapter 17, mechanicals. 1831, music protection added to the timeline. 86, Bern Convention. Respect to territories. U.S. did not join yet in 1886. You have the word remunerate, which is pay. 1908, Teddy Roosevelt getting heat, so he made the 28 plus 28 copyright. First comprehensive copyright law, compulsory license equals the first. It's the compulsory license, mechanical license. In 1912, motion pictures were protected. Every frame had to be protected. That's wild from in 1912, every single frame. 1917, Herbert versus Shanley, PRO case, legal basis for ASCAP. 1947, Title 17, the copyright law codified as Title 17. 1972, you have the P copyright for sound recording, basically for sync at that time. 1976, Current Copyright Act, plus 50 years and termination rights after 35 years. It then later, after 1976, turned into life of the act plus 70 years. Okay. 1989, U.S. signs the Bern Convention. Established things like work for hire. 1998, add-ons to the Bern Act. Clinton did that. The DMCA, Digital Millennium Copyright Act. Safe Harbor Provision, Title 17, Section 512, limits online liability. That plus the Sony Bono Act, 70 years plus life. So that was 1998. So that's when, in 1998 is when it really turned into 70 years plus life of a copyright. 2014, online streaming, USC public performance. Streaming is both the mechanical and the performance. Performance has the idea in that sense of kind of like physics, like light is a wave and also a particle. So that's kind of a cool way that my teacher explained to look at that. Whereas, yeah, streams are both mechanical and performance royalties. 2018, the MMA Music Modernization Act, and that also created the MLC Digital Licensing Coordinator, I believe. It's kind of built off of the index cards of Henry Fox Agency. The MLC is believed to be paid by the DSPs directly. The compulsory license at that point basically equals you can't say no. Statutes for producer fees, question mark. Okay, yeah. Always going through that. Charging for studio engineer, retaining CNP. 2020, Copyright Alt Small Claims Court, the Case Act. Termination clause, only in the U.S. Copyright is a balance between public access and incentives. Law exemptions to copyright. Okay, so public domain, obviously, that's 70 years plus the life of the artist. Last living artist, I believe, or copyright owner. Fair use, that almost always ends up in a federal or Supreme Court. Compulsory license, once it's been released, can be covered / performed. Okay. Number 4, First Amendment rights, freedom of speech. People are allowed to talk about it. Okay. Congress can extend a copyright to nobody else. Kind of redundant here and there, but all of it works together. All right, so you got like proactive payment. The artist is proactive payments, and the record label is retroactive for the producer, paid in the black. So retroactive means that the producer gets paid from record one. Artist means proactive payments after a certain amount of records are sold. So for the P record, maybe it's 100,000 in sales. Artists will that they owe. So the artist gets $0 until they reach the 100,001 mark of record sales. That's prospective. Producer will get 100,001 sales retrospective. Player pianos displays the music. Didn't have to know how to play to listen to music in average homes. It's always just really interesting to think about that versus AI now. So in copyright, the copyright.gov register of your work, ECO registration, there's general versus targeted. If you think you have a hot single, go with targeted, not general. You put a bunch of songs into, say 10 songs into a work under a general copyright, arguably you can potentially only get paid 1/10 of what you're going after because of that. So targeted if you know that the song's going to be big. The ECO registration, standard application, whatever, natural language versus Boolean search. Okay, Boolean search means case sensitive, special letter sensitive. Form SR for the phonograph. C, regular copyright for the intellectual property. Co-rights 50/50 unless external agreement. Otherwise, normal course of business. Make a list of recording. So that's something I had to do. Every agreement asks to waive. So apparently I think I have a note in here saying for every agreement asks you to waive your moral rights, even though it's under the Bern Convention. The right to privacy, right to publicity, name, image, and likeness is a state right only. Apparently Tesla can't turn off data collection. That's interesting. The little note there. I don't know if that's fully what they're doing with that with Tesla. So I'm not a lawyer, not giving any legal advice, not giving any, just taking notes, trying to understand it all. Tech is just ahead of legislation. Moral rights slowly going to creep into the timeline. Okay, so we can expect the moral rights to creep into the timeline probably. Section 106, rights to make derivatives. ccb.gov, Copyright Claims Board. Digital twin, you may not have the right. Yeah, tech is, yeah. Go over that stuff a little bit. We're going to dive way deeper into all this. I'm just kind of getting an overview of my notes here. My favorite things, Sound of Music, Straight Waltz, 3/4, derivative work would be John Coltrane. Replacing the chords, 3/4 syncopated. The Bottle Let Me Down, Merle Haggard, Tonight, The Bottle Let Me Down, Throw Rag. That's right, server, no copyright. Fair use is on page 337 of the Passman book. Transformative. Did you change and make a statement unique? Craft. Okay. Might want to jump into some of my other notes. Okay, we got the math. I'm not going to do a video about that because I already did one. Cross-collateralization, watching out for recoupables. I guess your manager could say, hey, label, you're trying to recoup recording investment of C, not P. P is all you get. So that's really good to kind of understand that red flag in a record contract and public contract. 12 songs on an album, yeah, that whole math thing. Controlled composition clause, that's the whole idea of like typically 75% of the statutory rate, capped at 10 songs. So, yeah. 93 cents a song rather than 1.488 and capped at 10. The two shoe theory of the copyright versus the phonograph recording, which is open to negotiation on the master side, or the phonograph, and the copyright song is 70% is controlled, which we know that of the income. So public performance, sync mechanical, section 106 limited duration monopoly is kind of in between the two. Really the neighboring rights is the artist performative rights, is your P recording, and then print goes to only the copyright, not the recording, obviously. So all your income that like in your public performance, sync, and mechanical is coming from both the copyright of the song and the recording of the song. So ultimately you want both. And I'm just going to throw it out there. My whole thing is, unless somebody's investing extreme money or paying you off, everyone at this point deserves, that was actually in the inception of building the song and the recording, needs both. And I'm not here for you only get this and you only get that. That's just my personal opinion, and I fight for that all the time in whatever I'm working on. A lot of deals will get blown, but you know what? Not every deal is meant to go through. Maybe the song will be sung better or performed better elsewhere, where you actually get your fair shake. So under Section 106, you can reproduce the work, distribute copies of the work, perform the work publicly, PRO's handle, make a derivative work, display the work, in the case of sound recordings, to perform this copyright work by means of a digital audio transmission. And the MLC takes care of that part of the equation. You could always ask your lawyer or something, what's the penny rate? What am I actually getting? And that's kind of like getting down to the nitty gritty. Producers are, again, retroactive to record one. Artists are proactive after recoupment to the perspective side of it. That's kind of like where I'm a producer on some records, and a record label is supposed to be paying me no matter what. And they try to tell me, oh, well, the artist hasn't recouped on the advertising costs. And then I tell them, well, that doesn't matter to me. That's the artist's deal with you. I'm an outside writer and producer. And I've actually done that with a pretty major label once. And it kind of led to the person who signed the song to be like, questionable of like, what, did you know what you were doing? Okay, well, then you'd have to pay. Not naming any names. Yeah, primary writers, secondary writers, if you so choose to build agreements around that. U2 was one of the first bands to kind of just say equal, rising tide lifts all boats. I believe in that kind of stuff. Honestly, the numbers are so confusing as it is that I really do believe that at this point, just keep it even. Like, this isn't the gold rush necessarily, and even if it was, we can all take care of each other. Yeah, it's funny. Roy G. Biv, like measured wave particles, red, orange, yellow, green, blue, indigo, violet. You got your outside writers. Solicit songs by performing. It's a big thing right there. Just to kind of like take a little side tangent, is like everybody's like, oh, like how come labels don't listen to your music or whatever? They can get in legal trouble for listening to stuff if they end up coming out with a copyright later that infringes on your work that they listen to. So the best way to solicit your songs, if it's not coming from a lawyer inside sources, is to just go out and perform your songs. And so many people go through classes or ask me as a producer, writer, ask an artist, like, how do I get my songs out there? How do I solicit my songs? And it's like, okay, you perform it, whether it's on TikTok, whether it's going to hotel cafe or playing at a state park or whatever it is. Like, you got to get it out there. Many artists are writing their own songs these days. They don't really need outside writers. Safe Harbor, Section 230. Google fix helped YouTube for the compulsory license covers belong. I don't know what that word is, but regulated. So yeah, the Safe Harbor, Section 230. There was a whole situation where YouTube was like really kind of on the fence of infringing a bunch of stuff, and I think it was Google who came in and like kind of bailed them out. Termination rights, 35 years plus the language in the contract. If there is a termination right, then it was an assignment, not a work for hire. And if it is an assignment, then yes, it's licensing. If it's a work for hire, then it's not there's no termination, right? Because it is explicit. And it's a work for hire. You don't get to terminate something that you don't own. It's easy to find versus control composition clause if it's a work for hire. And also cross collateralization. Work for hire is going to be a little bit more easier to find in your contract. Foreign mechanicals. PPD. Price per distributor. Beam. Then you have your MDRC, minimum delivery release commitments. So yeah, MDRC is one thing. Yeah, I know that. And then you have the commercially and technically satisfactory red flag language. Out of those three words, you want to take out commercially. I personally went on a rabbit hole of trying to understand, is advertising model better for profit than subscription model? And as of right now, actually, its subscription models are killing it. Advertising is so spread out at this point. PRO is paid first by the MLC under the Music Modernization Act. PROs that are paid first, subscription CRB Copyright Board 2024 is 15.20%, 2025 is 15.25%, DSPs greater than 1 million GMR per year. So I think that's just the whole idea of GMR as a PRO only takes serious numbers like and like ASCAP, anybody can join. BMI, anyone can join. SESAC, you have to be invited, but it's not too difficult. GMR is like, nope, you got to have a catalog that's moving. I believe Manet.com. Manet.com is music streaming royalty calculator, and that's where you could sort through all the inputs of royalty calculating, including the guide of podcast and music. Yes, Sony, Warner, and Universal invested in Spotify initially. Got into some Debussy, French composer, Edgar Stravinsky, Arnold Schoenberg, the Blues 145, sorry. Yeah, you want to join the MLC, you know. Mechanical review, physical and downloads, 12.4 cents, song up to 5 minutes. Example, album singles, digital downloads. CRB, Copyright Royalty Board, Interactive Digital Services, Section 115, CRB. Yeah, again, I said this before, the 2024, 15.20, 2025, 15.25. CRB negotiates with publishers and PRO to agree on rates. MLC, Mechanical License, Collective. Admin fee is 0 because Spotify, Apple, Amazon, Deezer, all of those DSPs pay for it. The MMA mandate for Congress, Safe Harbor, solved the DSP issue. MLC public database. KPIs, key performance indicators, obviously DBA, doing business as, or also the death by acronym, haha. Music career phases, the hobbyist versus headliner. Tribute bands are awfully easy to make money off of, not dealing with all the publishing necessarily. Archive department throws most anything 10 years or 15 years ago, dominating the streaming. That makes a lot of sense. Manager buffers label and artist, of course. Publisher can't break a band or artists. Typically, they collect and distribute, connect with song opportunities and stuff. Outside writer gets accounted for first. Outside writers get accounted for first. If you find yourself writing for a record label or somebody signed to a record label and all this stuff, and you got in the room somehow because somebody invited you and blah, 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 and the artist wants to work with you, and then the label tries to come in and say, well, blah, 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 this and that. That's what we have with our artists. You could say, no, I am an outside writer, and you all should not be asking people to do free work for you. So you're going to have to pay me. You should know better. Management usually gets 15% gross every penny that comes in. Always want to ask if you're buying the song, licensing it, or buying the copyright. Publishing deal should say at source. So on the co-pub, your song copyright gets 50%, and then the actual phonograph 50% gets split between whoever. And under a co-pub agreement, you get your 35 termination. You get your copyright back if you follow the rules to get it back. Assigned versus work for hire, we already went through that. Agreement, intellectual agreement, admin deal, business agreement. Management usually like 5% or less. And then you also have a songwriter agreement, obviously. Marketing email lists were relevant since the 90s, still more than ever. All right, next we'll go into Porter's 5 forces. But for right now, I think I'm going to call it.